So I'd like to thank everyone to our Legal Gold Rush series today with Crispin Passmore. Very, very excited to have him joining us today. Just before we get started, a few reminders. If you're interested in hearing the previous speakers in this session, please go to our website, legalinnovationzone.com. We had some fantastic speakers, including our last one was also from the UK, Christina Blacklaws. So please go there to check them out. Great conversations. Also, just a reminder for questions, please use the chat function and send the questions to Chris Bentley, who will be moderating today's conversation. So if you have any questions, please send them along. Most of them, many of them will get answered, as many as we can, but please send them to Chris Bentley in the chat function. And as always, we are recording this session. And so just know that it is being recorded and it should be up on our website in the next 24 hours or so. So without further ado, I will hand it off to Chris.
Hey, thanks very much, Hirsch, and welcome everybody. It's my pleasure to introduce our special guest coming to you from Kenilworth, England, Crispin Passmore. He's the founder's managing director of Passmore Consulting, but that's really a small part of the reason that he's here. The reason that he's here, in large measure, is Crispin has been a spokesperson for better regulation for lawyers for decades. Probably most importantly, as the executive director of the Solicitors Regulatory Authority between 2014 2018, when they were really implementing the opening up of the legal market in England. And just for all those viewing, the Solicitors Regulatory Authority has about 125,000 solicitors in England and Wales. But long before that, as a strategic director, as a policy director, with the Coventry Law Center, long before, Crispin, you've been involved for decades in this area. Now you consult internationally. And welcome to our program.
It's great to be here, really exciting.
It's been an extraordinary couple of months and an extraordinary couple of weeks. And I just thought I'd start by asking you, how are you feeling? What's the feeling in England among your friends and colleagues?
It's strange times, isn't it? And, you know, I think for myself, it's always just good to stop and reflect and look out the window and think I've got a nice garden and I live in the countryside, and how much luckier I am than many other people, because we know of, you know, so many people living in difficult circumstances, let alone those with health problems, with illness, and sadly even the hundreds of thousands around the world that have died. And it feels like a moment of change for the world. And I'm always really hesitant about saying that because, you know, we say it every time anything happens, and I'm always really skeptical about these moments of change. But this does feel like one. And the last couple of weeks, yeah, events in the US and demonstrations around the world following the death of a black man at the hands of the police just feels even more significant. How many times have we been there before? And, you know, I think it just brings home to me the importance, both those issues of rights and justice. You know, we give people rights, rights to speak, rights to a fair trial. They're meaningless without a justice system supported by lawyers. So, you know, it seems like a really significant time for the world at the moment, and it's, you know, it's good to be safe in that time.
Well, let me start there, Crispin, and ask you, why should people generally, or lawyers, care about regulations? Why should we care what the legal regulatory framework looks like?
I guess, you know, there's two ways of coming at it. One is just to link it to those two issues, isn't it? That, you know, rights are what makes our society work. They're what allows us to have relationships individually, whether they're personal relationships, consumer relationships, or business relationships. They underpin our relationship with states and between states. And those rights are not a reality unless they're backed up with access to advice and access to justice system. And, you know, I think there's a lot of difference between the rule of law and the rule of lawyers. but lawyers are important in the rule of law, and therefore how they're regulated in a way that promotes the rule of law and increases access to those rights in a way that makes those legal rights a reality seems to me to be really important. Secondly, I would just say, you don't have a choice but to care about regulation, because regulation isn't really just about the rules that the regulator writes. I think we should look at regulation in a more holistic way. Regulation is about the rules that regulators write, but it's also about the rules that exist in consumer law and competition law. It's about the culture that exists in a society amongst people and businesses. All of those things provide the infrastructure that creates incentives and disincentives to good and bad behaviour, and all of those things are regulation. And when we talk about regulation, what we really are thinking about is all of it, but what we actually talk about is just the sector-specific rules, and it's good to keep them in that context of everything else.
Well, it's interesting that what you started out with, Crispin, because the whole point of democracy is that we get to choose our leaders, and sometimes we choose them because they're advancing an agenda. Sometimes we choose them because they're going to stop an agenda, and they reflect our views in legislation. But then if we don't have the right to the benefits of the legislation, if we don't have the right to access the means of enforcing the rules that come out of the legislation, it's almost undermining democracy.
Yeah, and I think you can see that in the US at the moment, can't you? And you can see it in the way that so many Black people and others that support the equal justice that they're standing up for at the moment. They would say quite often, "Well, I haven't got access to rights. This is a centuries-old debate, and it's meaningless to have fought a civil war. It's meaningless to have fought a civil rights campaign if you don't give me access to those rights as well." So it's just hugely important.
Now let's step back a tiny bit and just give us some context. How did the opening up of the legal market start in England and Wales, and why did it start?
I guess like a lot of developed countries, we've got an ongoing debate over the quality of access to justice. But it's not just an access to justice debate in the UK, it's an access to legal services to support business as well. Back in 2001, this is how long it takes, I guess, for reform to happen. Back in 2001, our competition authority at the time, that was called the Office for Fair Trading, published a report called Competition in the Professions. And it said, I'll give you a quote from it, actually, it happens to be on my screen, so good question. Restrictions on supply in the case of professional services, just as with other goods and services, tend to drive up costs and prices, limit access and choice, and cause customers to receive poor value for money. Such restrictions tend to inhibit innovation in the supply to the detriment of the public. That's where we started with our professions, and my involvement has been with the legal profession, but you can lift and shift into most other professions and probably most other trades too.
I like the fact that you broadened the access to justice conversation, because for so long, from the time I started as a lawyer, it's often been used to speak to the marginalized, the poorest in societies, those who have no legal aid and no means whatsoever, no voice, but you broadened it to really include people of all different means, businesses that don't get access to the help they need, and that has a much broader effect on society.
Yeah, I think back in 2009, when I was involved in setting up the Legal Services Board here, which was put in place to oversee all of the different regulators we have and to implement our legislative reform, one of the things we looked at and demonstrated quite clearly, and this is pre-legal aid cuts that took place subsequently, was that actually individuals with the worst access to legal services were those just outside of legal aid. So still really quite poor, because our legal aid system, well funded as it was back then, really went to very, very poor people. People on average and below average wages had almost no access to legal services. There was a little bit more if you were eligible for legal aid, much more if you're very, very well off. And also when we did research on small businesses, what we found is that patterns of problems and patterns of access mirror completely those of individuals. And I think one of the things we all got to look at is small businesses are just people in disguise, and we need to give them access because they're the engines of our economy, they're the engines of our job markets, they're the engines of our innovation as well.
Now, you referred to that 2001 report about restricting competition, restricting choice, restricting innovation, restricting access to the services they need for the marginalized, the middle income, and businesses. You've traveled the world. You've spoken around the world. Is there any reason to think that it's different in Canada and in the United States than it was back in the UK?
No, sadly not. The world's much the same all over, isn't it? Everything looks a little bit different when you're really close. But if you take the steps back, you see the patterns. And if you just go to patterns of legal need, first of all, so you look at the ordinary legal needs of our citizens, study after study around the developed world shows that the pattern is pretty much identical, not just in the volume, but in the who experiences problems, what sort of problems they experience, the patterns those problems occur in. It's replicated in study after study over the last 25 years, particularly. The same in Canada, the US, the UK, other European countries, Australia, Hong Kong, Singapore, etc.
And I suppose, so if you start with the 2001, you've had a traditional legal culture in England, as traditional as they get. And one of the arguments against change in Canada and the United States is, well, we're a traditional profession, we move slowly. How did you move relatively so quickly in England and Wales, given your tradition of the barristers, the solicitors, the Inns of Court?
In short, we stopped asking them for permission.
Can you just stop there for a minute? You stopped asking them for permission.
Yeah, we stopped asking the lawyers if they thought it was all right to change.
So I just want to stop there for a second, because regulation springs from a different well depending on where you are. In Canada, it is the provincial legislature that has granted the monopoly and the right to regulate. In England, do I take it, in England and Wales, do I take it was the same? It was the government right.
Yes. Yeah. So it's legislation. What we had is a hodgepodge of legislation going back. Actually, the oldest bit of still in place lawyer regulation goes back to 1535, and the legislation that dissolved the monasteries when the UK broke from Rome. That took the regulation of notaries away from the Pope and handed it to the Archbishop of Canterbury. And he still has that responsibility. So it is quite traditional. But our legislature took the decision in 2006 to put in place an oversight regulator across solicitors, barristers, etc., which were self-regulatory bodies. That's an independent regulator of regulators, and part of its obligation, duties, powers was to require those professional bodies to regulate in a way that is beyond the reach of their representative influence. So to start to create a sense of independent regulation.
So fast forward to today, what does it look like today? If I was not a lawyer, if I had other expertise, what am I not allowed to do?
So I think one of the interesting things for the UK, and this is why I think when other countries look at us for evidence on whether they should allow non-lawyer ownership, is you've got to understand that there was never an unauthorised practice of law regime in England and Wales. So we had 6 reserved activities that only a regulated lawyer could do. And we have more than solicitors and barristers. We have other types of regulated lawyers as well, a bit like limited license practitioners. Those 6 reserved activities grown up over history, back to notaries, but the core ones are advocacy in a higher courts, litigation, residential and commercial conveyancing of property, and probate, and there's a couple of others as well. So those are regulated and reserved as a monopoly to lawyers, and the title of solicitor is reserved to those that are members of the Law Society. But beyond that, we've never had an unauthorised practice of law. So we've always had a tradition of, me as a non-lawyer, I could set up a company and start writing wills. I could do general legal advice. I could do commercial legal advice. So we already had a thriving legal market beyond the reach of lawyers. Now what you can see is that lawyers can practice in more varied ways. So they can practice with other professionals. They can practice in businesses owned by non-lawyers, entirely owned by non-lawyers. They can practice in businesses that are not regulated, that are not delivering any of the reserved activities. So they can float on the stock market, they can take external investment. They can behave as businesses, that's the bottom line.
Well, this is the feared ABS, alternate business structures. And are lawyer ethics harmed if they have a non-lawyer owner?
No, we can say that categorically. Because we've got 8 years of regulating them under our belts, and we've got independent evaluation of this, and we've got plenty of anecdotal stuff to back that up. I guess the key is when we talk about liberalising, deregulating, re-regulating, reforming regulation, none of us are talking about let's tear up the ethics rules. None of us are saying, okay, let's change the rules so it's okay to misuse your client's money. Let's make it so it's okay to lie in court. The ethics rules are untouched. What we're talking about is changes to the economic rules about how you practice, what sorts of businesses you practice in. And I guess what I've said to lawyers for 15 years is, are you telling me your ethics are so weak that if you sit in a business alongside another professional, you might do bad things? That doesn't sound to me like you've got strong ethics. That sounds to me like your ethics are really fragile. But I've got more confidence in lawyers than perhaps lots of them have. So I'm not at all surprised that the experience of England and Wales is that, less complaints, no greater ethical issues, more innovation, etc., etc.
So you have documented evidence that there's no ethical decline.
Yes.
That there's greater innovation.
Yeah, there's a series of independent studies. As somebody once said about the French Revolution, it's too early to tell. We need 20 or 30 years before we can really say, to the satisfaction of the naysayers. But 8 years in, we haven't got a bunch of terrorists from anywhere around the world suddenly owning law firms. Although we have still got some lawyers that launder money for them. But we deal with them appropriately.
You deal with them appropriately because there's still an ethical and professional responsibility structure.
Yeah, absolutely.
So let's talk about the ABSs. What kind of ABSs have developed and how are they working?
So I don't think there's a single bit of the legal market that's not touched by sort of this sort of innovation of non-lawyer ownership, non-lawyer involvement. So, you can look online in the UK and see a business like something called Fairwill, which provides an online will writing service, unregulated, employs a couple of lawyers, but most of it is paralegals doing the work and smart technology. Lawyers pour their brains into the technology. You can look at small businesses that either just employ paralegals, or some of them employ solicitors as well, that give unregulated advice entity level to small businesses and all sorts of other businesses that are the people that weren't accessing legal services before. And you can see all the way through up to businesses, law firms that are floated on the stock market. We've got 7 currently that are floated. We've got the big 4 accountancy firms. We have private equity-backed businesses like Axiom, Elevate in the UK, Rocket Lawyer, LegalZoom. All of these. Always strikes me, isn't it funny that Rocket Lawyer can do more in the UK as a visitor than it can do in its home state or its home country. Thanks very much, America. We'll take that.
Is there, and all the jobs with it. Is there
No, absolutely.
is there an advantage to, let's call them traditional lawyer-held partnerships if they get outside investment? And what is that?
So for some and for others not. I guess at the moment it's really interesting, isn't it? You know, whether we look at law firms or any other businesses, who's going to come through this sort of a lockdown and economic hit that we've never really seen the scale of before? Who's going to come through it well? Well, I guess to me, a strong balance sheet, tech-enabled, know your customers, understand risk. Strong balance sheet. Well, it's really hard for a partnership to have a strong balance sheet. It's much easier. It's not impossible, but it's much harder. It's much easier for a corporate that doesn't distribute all of its profits automatically every year. So, you know, you can strengthen your balance sheet. That allows you to take risk and take a longer term view on investment. Really hard to for a partnership to take a 10-year investment on technology, to move into other markets where that's required, and to build the scale that's needed to reduce cost in certain types of services. So there are advantages, but I don't think it's about better or worse. It's about just saying, you decide what services you want to deliver to customers. You decide what sort of workforce you need, what sort of business structure you need, what capital and technology you need to support that. We won't constrain it artificially. You're the business person, it's your business, you decide how to structure. But however you structure will hold you to the same ethical standards.
And just to be clear, alternate business structures, they're different than alternate legal service providers.
Yes. So an alternative business structure, I don't know what it's alternative to, as in same with alternative providers, but it's like alternative medicine, isn't it? Alternative to medicine that works is what I always say on that one. What we're really looking at is non-lawyer ownership. So where some of the ownership of the business is beyond lawyers. That can vary from a small amount through to 100%.
Right. And apart from the investment, does the ABS alternate business structure non-lawyer ownership allow a law firm to acquire different forms of expertise they wouldn't otherwise be able to acquire?
Yeah, without doubt. So some of the really early, and I'd say about a quarter of the ABSs we've got are quite traditional law firms, often quite small, but not exclusively, where they have taken their senior non-lawyer staff into ownership. So whether it's their IT director, their finance director, their chief exec, the husband or wife of a sole trader that's actually been the driver of the business, while the lawyer is the driver of the expertise. And they have just brought that person into ownership and given them aligned incentives and reward for success. Doesn't change their business really, it doesn't change their business model, but it has allowed them to retain and perhaps attract high caliber people. I think that is increasingly a debate amongst big law firms as well, where they have really significant numbers of non-lawyer professionals at the top of their business, yet when the decisions are made, all the lawyers go in a room and exclude them. Othering is alive and well in the legal profession. Why would you stay in a business like that if you've got ambitions to be at the top? Converting to an ABS allows you to bring those people into ownership.
So at least on the English and Welsh experience, don't want to miss Wales in there, the English and Welsh experience, that the evidence does not support any diminution of lawyer ethics or standards. You increase consumer choice and you give the business owner, the lawyer, an option on how she or he runs their business and how they direct their business. What about the issue of innovation? We always talk about how we often talk about how the legal profession is behind in terms of technology. Have you seen any change as a result of the outside investment?
Yeah, it's always hard to say cause and effect, isn't it? There's so many moving parts to business and consumer demand at all levels that it's hard to say, A causes B and therefore C. But what we can say is the evaluation, independent evaluation that's been done so far suggests greater innovation amongst ABSs, greater investment in technology, new products, new services, new ways of doing things. I don't really think that's a surprise. I think if you just test it with well, what would you expect? Well, if you bring people into a business who have picked up experience from other markets and other businesses, you're more likely to bring that learning into doing things differently. Whereas in most law firms, the only way to the top, to be a decision maker, is to start at the bottom and have every bit of innovation hammered out of you over 20 years. It is just really difficult. So it's no surprise that we see more innovation in those sorts of businesses.
What about the people who use either alternate legal service providers or ABSs as opposed to wholly lawyer-owned firms? Is there any difference in consumer satisfaction?
Not really that you can see. If you look at complaints as a measure, and you've always got to be careful about looking at complaints, sort of customer service style complaints, not regulatory style complaints, but customer service style complaints, because, is more complaints a sign of doing well or doing badly? I would say a business that welcomes and embraces complaints and deals with them well actually is probably going to get more complaints than a business that, charges you £400 an hour for responding to your complaint letter. I'm wary about just looking at numbers, but if you look at ABSs, the research that was done suggests they are more likely to train their staff on recognizing and handling complaints, and they're more likely to have complaints that lead to satisfied customers. Mm. So, I think that all points to, a positive experience. But I wouldn't say a business that simply takes non-lawyers into ownership will automatically be better at this stuff. Actually, I think it's probably correlation, not cause. The businesses that are open to investment and non-lawyer ownership tend to be the ones that are open to doing things better generally.
Is there any suggestion or evidence that the service provided by the lawyers is better or worse than service for the same type of service provided by the non-lawyers or the mixed?
No, not at all. And as I say, every single bit of the legal market for individuals, small businesses, corporate clients, there are ABSs to choose from alongside traditional law firms. And some of these might be less sophisticated customers and not so good at making choice, but an awful lot of them are very sophisticated customers, and they keep using ABSs alongside traditional law firms. I think that speaks volume. And when we look at the most marginalised, rather than worry about the theoretical risks, let's look at the real risks, the ones that we have day in, day out where we started, which is access to justice. For individuals, the debate about innovation, non-lawyer ownership, fee sharing, all of these things around the world seems to me to be a debate between millions of people harmed by having no access versus a few people theoretically at risk of getting advice tainted by non-lawyers. Well, one's real and one's not real. One we've got evidence for and one we haven't actually got any evidence for, and we've got lots of evidence the other way. So, I think the evidence is pretty clear in all places that consumers benefit from choice and that choice drives innovation and quality and price.
Okay, so if I'm a lawyer and you're proposing to open the market up, I'm going to worry I'm going to lose my business.
Yeah, and you might. I don't think we should shy away from that. I dream of having new skills and being a restaurateur. But I don't look to our food standards agencies to make sure I succeed and am profitable. I look to my customers to tell me whether I'm getting it right. And if I don't get it right, well, I will go out of business. But I would say lawyers shouldn't be scared of competition. Look at it another way. You mentioned at the beginning we have 125,000 lawyers. It's great to talk about the number of lawyers in England and Wales because it's way more than that now. There's about 150,000 practicing and there's about 200,000 on our roll. It doubles every 20 years. if we'd gone back 20 years ago and said, what would another 50, 70,000 lawyers do? We would have gone, I don't want that competition. What do they all do? You know, quality will fall. You're letting in all these dodgy people. And yeah, if you'd gone back to 1970 or 1960, when there was 20,000 lawyers in England and Wales, and you've been said there's going to be 200,000 in 50 years' time, people would have just been alarmed. You know, so I don't think people should fear new entrants and competition. This is a market that we want to grow. You know, we all care about unmet legal need for individuals and small businesses. We care about legal advice for large businesses because it's the sort of oil that makes the engine work of our economy often. Yeah, we want more of it so that we can grow our economy, and that's good for the legal market as well. So, you know, it's rubbish if you're a rubbish lawyer. But actually the current market's probably rubbish if you're a rubbish lawyer as well. So yeah, there's nothing for lawyers to fear. In the 20 years since that Office of Fair Trading report, we've got more lawyers. We haven't got less.
England has fancied itself and has lots of evidence to support that you're an international center for law and you export your services. It really is an industry that you look upon as an international center of excellence. Yeah. And there's some evidence and some indication the government continues to support that, in particular innovation. Tell us a little bit about that and what's going on.
Yeah, well, I think the UK has seen itself, you know, because of history and accidents of history perhaps, but it sees itself as an outward-looking country. It doesn't always get it right, and it doesn't always look out with the right views, of course. But it sees itself as a trading nation, and increasingly it sees itself as a services-based, knowledge-based, forward-thinking, technology-based trading nation as well. And you know, our professional services are hugely important to the UK for two reasons: not just for export, but for inward investment as well. And that, to me, is part of opening up our markets. One is to bring inward investment. So, whilst London law firms may not be particularly delighted at the arrival of so many Americans, you know, the UK government and UK public is, because it's inward investment and it's grown our legal market and it's helped us, you know, compete across the world. So, you know, absolutely do see it as that. It's backed through regulatory reform. It's backed through support for the legal sector in things like technology and innovation. There's a range of things that go on in different industries. You know, controls around state aid across the European Union, rightly so, I think, and always wary of government trying to pick winners. But there is support for technology in the legal sector and support for innovation with the backing of money, task force, regulatory reform, etc. And that's why something as dry as legal regulation does get airtime amongst our Parliament.
I'm going to come back to that, but there was a question: is there any difference in the cost for consumers when the consumer chooses an ABS versus a traditional law firm to deliver a legal service?
Almost impossible to answer simply because there's so many things that affect price. You know, there's levels of demand and all sorts of things. But we can point at a few things that I think are interesting. One is that for retail customers, for us as individuals buying legal services, getting a will written, doing probate, doing your conveyancing, we have huge variation for those prices across England and Wales. You can go from one town to another and you might pay £2,000 for a probate in one, and you might pay 20,000 in another, quoting exactly the same information. What we're beginning to see is a narrowing of that differential. So we're beginning to see the revelation of a market price, which is obviously a lot lower than 20,000, but actually not necessarily at the £2,000. So I think that overall is good for consumers. It gives them real choice. There's some things, there's other parts of regulation that drive that rather than ABS. So for example, one of the last things I did at the SRA when I was there was we imposed on law firms a requirement to publish their prices in a whole bunch of areas. Yeah, hugely resisted, hugely resisted. And we only got that through with the support of our competition authority. Yeah, I think I only got through the organisation with the support of the competition authorities. That is really starting to make law firms think about their price. National law firms can't get away with charging higher prices in London when the service doesn't need to be delivered face to face. So we're beginning to see law firms move production outside of London, and the current pandemic is helping them think through how to do that faster. One of our bigger retail law firms has just announced it's closing its London offices and moving entirely to remote working. Because it can reduce its costs. So I don't think you can simply say ABS leads to lower price, but you can say competition leads to lower price.
Coming back to the international investment and then the export of services, you have the big four consultancies, which now each have their own law firm.
Yeah.
Although long before that, they were providing legal services of various sorts.
Yeah.
Is there any evidence that they can now service, say, international corporations which might otherwise have had their work done in Europe or United States, maybe Canada, but now they can serve them for the most part out of an English base?
Yeah, that's definitely beginning to happen, and not just for the big four, but for some of the businesses like Elevate and Axiom and United Lex and businesses like that as well. I think that the first thing is to say, we don't look at it as the big four owning a law firm. We would say they are a law firm.
Right.
So we don't require them to set up a separate vehicle and for it to be, in a separate office or with a separate IT system. We just say, no, you're regulated as a law firm and your lawyers can work alongside everybody else. So we have facilitated truly multidisciplinary teams as well as truly multidisciplinary practices. And that needed some imagination on how you regulate, but we worked with them and others to work out how we would do that. So they are without doubt growing. So PwC probably now about the top 80 law firms in England and Wales in its legal businesses turnover. And that probably understates their turnover. Are they able to serve internationally? Without doubt. At one point, Deloitte was opening over a 4-year period. I don't know their most recent numbers, but 12 months ago, they were opening in a new jurisdiction, legal services, at the rate of 1 a month. A law firm moving to a new jurisdiction is a once a year or twice a year at best choice because it's opening a new office, whereas for the big four, they've got the infrastructure there already. It's just hire a few local lawyers and stick them in the corner. So, they're able to do it because they've got scale, they've got systems, they've got cultural awareness of where they're landing, and all of those sorts of things, business awareness as well. They're starting to serve more from the UK. Certainly, I've talked to one of them about how it might do that much more aggressively in the US. Difficult for them because they're interesting businesses, aren't they? Because they're not really single businesses. They're a series of local businesses connected up to an overarching board through a sort of Swiss Verein structure. So there's quite a lot of national autonomy within the big four. So I think that the more robust global expansion is coming from businesses like Elevate, United Lex and businesses like that as well, and Axiom as well, who really are global businesses standing alongside their global clients.
And is their market a corporate market, a small business market, or what is?
Corporate market. So, what those sorts of businesses are doing is creating a range of products or tools to do specific tasks for GCs of corporate clients. I think it's a difference how they market themselves. Traditional law firms have lawyer expertise and try and sell their expertise on a bespoke basis. What what we call alternative providers tend to be doing is look at the tasks their clients want done and find ways of doing them efficiently, reliably and cheaply through a mixture of whatever will deliver the price, the quality, the ethical standards that their client demands. And that might be technology, it might be flexible lawyering, it might be a managed platform, it might be paralegals. And they're aiming to lift work out of in-house teams in GCs, and increasingly to partner with law firms to do the volume stuff alongside a law firm when it goes onto a client's panel.
If I was a regulator in a Canadian jurisdiction, looking at the question of whether to open up or continue restrictions, what would your advice be?
I'd say go home to the town you live in and ask yourself if you should only be allowed to buy goods and services produced in that town. Should you only be allowed to buy a car if they make cars in your town? Should you only be allowed to buy food that can be grown in your local area? And of course the answer is no, because it's a nonsense idea. Well, let's apply the same to our service industries, which actually are even more amenable to remote cross-border delivery. So, if you want to have the choice of more than you've got at the moment, because you want to reach more people and grow the market, then whether you come at that as a regulator, a member of the public, a small business, a large business, or the owner of a law firm, or a lawyer looking for work, well, of course you want to open the market up because you want to grow the market. And the only people really against it are going to be the people that've got a vested interest in resisting change. Milton Friedman said you can tell who benefits from regulation by looking who asks for it. I don't know many consumers of legal services that ask for more regulation. They ask for lower prices, more innovation, more choice, or even just basic access.
The theme for this series has been that there's a huge market out there of unmet legal need. It's not just this theoretical group of people who need legal services. That's actually a quantifiable market of services that lawyers and others could be serving. So if I'm a regulator, would part of my sell be to my lawyer members that in fact deregulation or removing restrictions can help grow your market?
Yeah, without doubt. If you look at all of the people that aren't currently served in any jurisdiction, whether individuals or small businesses, or corporate clients that are not being served in your jurisdiction, being served from London or California or wherever, if you want a slice of that and you want to grow to meet that need, then you need to be attractive for business and attractive for lawyers. And you've got to, this isn't some sort of mad free market agenda. This is about properly regulated markets. And why competition? Well, it's simple, because the alternative is monopoly. And I don't know many people that would go to the ballot box and vote for monopoly. So the opportunities for lawyers are to work in more businesses, to innovate earlier in their career rather than wait till they become partner of a law firm with a 5-year horizon. To reach customers they've not been able to reach, to deliver services in partnership with other professionals and other businesses. The limit is your imagination. And if you haven't got any imagination as a lawyer, well, there's still loads of opportunity for you, because lots of lawyer services will remain very traditional for a long time to come.
We started this conversation with a cautionary tale to regulators that don't want to regulate. When I asked you, how did a traditional profession in England and Wales change? And you said, we stopped asking the lawyers permission. What other cautionary tales are there for regulators, or what issues do they need to get right if they decide they want to open up?
I think there's a few things. I think one of them for the regulator is almost to shift the burden of proof. So, one of the things that's changed, certainly in the UK economy over the last 50 years, is we have much more consumer law and much more competition law that is pro-good markets than we had 50 years ago when our legal regulation was really designed. So given that the tide has lifted standards across the piece, we shouldn't be asking ourselves, is it safe to remove regulation? We should be asking ourselves, can we justify keeping it? And if we haven't got the evidence to justify keeping it, let's throw it away. And it's not to the satisfaction of the lawyers, it's to the satisfaction of the regulator. Have we got evidence? It has to be real, not theoretical evidence. I think That links back to the importance of independence of regulators, there to serve the public. I guess the other thing I would say, and I say this in the US quite a lot where I do work with regulators, it's really easy to talk about access to justice for marginalised, but let's not pretend there's a functioning market that delivers low-cost legal services to people that are homeless and have no income. That's not a market, that's a state subsidy. I'm all in favour of that, but a better functioning market might help there, but it's not going to solve the problem. Right. So we've not got to not stand and be too virtuous and say this is about solving access to justice. This is about growing a market, creating jobs, improving access to legal services for ordinary people, small businesses in particular, and that's quantifiable and huge, and focus on that. We should at the same time hold governments to account for the quality of legal services to the poorest and the marginalised, and we should do that through the ballot box, etc., and campaigning if we feel strongly about it. So let's not get sucked into, technology solves domestic violence or discrimination or those things. It can help, but it's not a magic bullet to those sorts of things. And the other thing I would say is, it takes time. Revolutions take 20 or 30 years. There is no big bang. It's not a switch we flick and the world changes. This is about gradually eating away at a series of restrictive practices over a long period of time. And non-lawyer ownership and allowing fee sharing is one of many. And each jurisdiction will have its particular ones. How the workforce qualifies, how the workforce practices. You've got to keep looking all the time at chipping away at economic rules and give lawyers freedom to be good lawyers and business people freedom to be good business people.
You have been involved with a number of different jurisdictions in the United States that are starting to open up. Just give us a sense of what's going on there.
How many times over the last 20, 30 years has the US walked up to the line and considered liberalisation and alternative business structures? And each time, when the lawyers got asked the final question, they said, oh no, we won't do that. It's a bit too scary. I think this time is different, and I think it's different for a number of reasons. One is that there's the emergence of the decision being taken out of the hands of state bars, elected state bars, elected professional bodies. So in California, the legislature changed the structure. It, in effect, kicked the representative functions out of the state bar and made them form lawyer associations. And it put independent and appointed people onto the board of trustees as the regulator. The lawyer voice against reform has been as strong as ever, but even just a couple of weeks ago, I watched their trustee meeting where they were considering the next step of regulatory reform. All of us expected them to say no, but as it went around the table to vote, all of the independent members supported reform, to the surprise, I think, of all the lawyers in the room. So reform, is happening in California. Utah and Arizona, driving ahead because of the commitment of their Supreme Courts, which have constitutional control in the US. Why state bars have got on side with that in a greater or lesser extent in both of them, particularly in Utah, but driven by an outside force than the lawyer monopoly, the Supreme Courts. And I think you look in DC and Florida, particularly as the two other bigger states that are following, and we see reform there as well. And other smaller states are starting their own things as well. So I think it's going to be different. I already know of businesses that are applying as non-lawyer owned businesses to start delivering urgently to meet the current legal needs of small businesses and individuals in Utah. And by the summer, it'll be happening in Arizona as well. It's a big, big breakthrough. I think it's inevitable that over the next 20 years, all 50 states will follow.
So let's just switch for a second. Let's say I'm a young lawyer. Let's suspend our imaginations just for a moment, or encourage our imaginations. I'm a young lawyer. I'm at the beginning of my career. I've either just been called or I've been out less than 5 years. I've been trained traditionally, strong training, but traditionally. I'm not particularly tech savvy. I I'm looking at a world that is tech savvy. I'm looking at a profession that isn't. I'm looking at outside providers potentially coming from all directions. What should I be doing?
Yeah, I think the world is your oyster. I think change has already been happening, certainly in the UK, but across the world. You know, the ways that you can practice as a lawyer have grown and grown and grown, and that's why the number of lawyers has grown and grown. So, yeah, you've already got choices about being in-house, about working in government or non-profit, as well as in, you know, the varieties of traditional practice, whether it's, you know, retail legal services or corporate legal services. All that's really happening now is that those choices are being increased. So what I would say to young lawyers is, what do you want to do with your next 5 years? I don't even think you need to think about your career. I say the same to young lawyers as I say to my own children. You know, coming out of university, they say, what do I want to do with my career? I say, you don't have to decide that. You just have to decide what you do for the next 5 years. You can make different decisions in 5 years' time, and we don't know what the world will be like. So what do you want to do over the next 5 years? What sorts of clients do you want to work with? What sort of people do you want to work with? What sort of business do you want to be in? And, you know, that should drive the decisions you make, and therefore the skills that you seek to acquire and the experiences you seek to acquire. And the good thing about reform is, you know, if you're in a jurisdiction that is opening up, those choices are not artificially limited. So you have more businesses that you might find people like you, people that you want to work with, clients that you want to serve, delivering products and services in ways that you imagined. And that might be traditional, it might be tech-led, it can be anything you want. But, you know, decide where you want to be and acquire the skills to let you do that.
What types of skills should I be looking at improving, acquiring?
So I personally, I think work increasingly, not just for lawyers, but for all of us, and across all markets, it's more about your behaviours and your skills than your knowledge. A friend of mine who's a lawyer says, you know, the law bit is easy, somebody wrote it all down. Yeah, I think the really tough stuff is people. It's how do you form relationships with your colleagues, the people above you, the people below you in teams, the people in other organizations or multidisciplinary teams you need to work with, in your client, in your business, with partner businesses. Yeah, so that's about your values, your behaviors, and your skills. And of course, the law, you need to know that is, you know, that's pretty basic. There was never a lawyer that advertised on the basis of I know the law. You know, well, of course they know the law. You know, what do you add? So I think it has to be all around values, behaviors, and skills. And I would focus particularly on collaboration. I think that's the truly important bit that levers out better value from other people and better value from yourself, is your ability to collaborate.
And that's at the heart of the opening up of the profession in England and Wales. It's at the heart of outside investment. It's at the heart of this competitive nature that you're developing.
Yeah. Yeah, and it's also at the heart of changes to the way solicitors qualify in England and Wales. So perhaps we talk about another webinar, you know, where there is a focus on knowledge, of course, because you have to know some stuff to be a safe beginner as a day one lawyer. But actually, how do you minimize that so that you create space in the curriculum for different sorts of educators and employers to add the skills and the behaviors and the knowledge that matter to their business, not that matter on average to lawyers, that matter to their specific environment, and allow a much more of a workforce strategy aligned to a business strategy, you know, and thinking about this as a business and a workforce much more. And I think that, again, just creates many, many more opportunities.
Well, if I wanted to be a solicitor in England, do I have to come to England for a certain period of time to qualify, or can I do it remotely?
Well, that's all changing. From the end of next year, 2021, the introduction of the Solicitors qualifying examination, various stages, it'll take some time. Lots of the inputs are being got rid of. It's an outcomes focused regime. You'll need to pass 2 pretty difficult assessments. Part 1 is your knowledge. It's a single best answer choice questions. That will be delivered online, and whether at the beginning in 2021 or very soon after that, you'll be able to take that in centres around the world. The second part is a skills assessment, observed structured clinical assessment, using a mixture of lawyers and actors to create scenarios that trainees are put into and assessed, with a whole set of rules around that, using knowledge as well, but it's about how do you apply it in real life and have you got the skills to be that day one lawyer. At first, that will only be available in England, but over time, over the next few years, as experience is built and they build the expertise to do that, that will be available in other jurisdictions around the world. You'll still need to do 2 years of work experience under the supervision of a lawyer, of an English qualified lawyer, but that could be anywhere in the world. So, a English qualified law firm, in Toronto, could create a centre for you to sit your exams and pass and qualify as an English lawyer. And that really is part of trying to make English law the law of commerce of the world by businesses based in London and a workforce trained in London. We see education as part of our services export alongside law.
As you were describing the skills part with virtual law firms and actors playing clients, it made me think of the law practice program that we run out of Ryerson. Crispin, this has been absolutely fantastic. Thank you very much. I'm looking forward to following up with you. We're looking forward to having you here in Toronto, in Ontario, at the conference we were supposed to have in March. But in the meantime, keep in touch. Look forward to the conversations. And with that, I'm going to turn it back over to Hirsch.
Thank you very much.
Thanks, Chris, and thanks, Crispin. That was a fantastic conversation. A lot to think about. A lot more research for us to do, and that was fantastic. So thanks. And for everyone for joining us, thank you very much. We will be announcing shortly our next series in the Gold Rush. Will be featuring Andrew Arruda from Ross Intelligence, and a good friend of all of ours on this call. So we look forward to having him, and that will be in the next 10 to 14 days. We just have to finalize the date. So thank you very much, Crispin, and for everyone, have a great day.
Thanks, Edge. Thanks, Chris. Thanks, everyone else. Cheers all. Bye.
Bye-bye.